I was awakened from my slumber to a plethora of messages from followers, from friends, from people asking that I please break down what's going on in the docket with these appeal docs, and I am flattered, truly. But remember, I am a certified law nerd and bona fide non-attorney, meaning that I also have to stop, read, do research, and make sure that I'm comprehending what I'm reading before I can relay anything to you. Now that I've had a cup of coffee, I've read, I understand, now we can break it down. It's actually pretty straightforward, but we did receive a little golden nugget. We now know what they intend to appeal with, so we're going to break that down. First, we have a Rule 7 transcript contract. This is pretty standard. The defense is requesting the full court transcript for the entire jury trial, plus any related proceedings, although it's technically only listing out the dates of trial. For context, just day 1 of the jury trial transcript was around 150 pages. The second page is the agreement itself, which is going to show what the transcriptionist's fee for the transcript is. Please note here that it is $7 per page. I just said that day 1 was over 150 pages. This trial was 6 days long, so you can do that math. This will add up very quickly. As I've stated in the past, appeals are expensive, and this is part of the process. Yes, for anybody wondering, that expense is on Brenay's dime. The attorney is not going to ask for this for free. Again, I am not an attorney, but the fact that they are requesting everything, the entire jury trial transcript, tells me that they are still reviewing the record to support the arguments they intend to raise. In other words, I suspect that some of these arguments are not solid. I feel like if they were, they would have done a more targeted approach where they are asking for specific days or asking for specific transcripts regarding testimony or evidence, admissibility, objections that were made. They are not doing that. They are asking for everything. And I couldn't imagine having a client pay for an entire transcript if I already know where to zero in. Again, that is just me observing and speculating. That is not fact. Now, the second document is where things get a tad more interesting. This is the appellate filing, where the attorney is required to list the issues they intend to raise on appeal, and these are not arguments yet. This is not the briefing, but it does give us a little framework. Now, let's walk through what they listed. First, there was a lack of evidence to support the verdict. In simple terms, the defense is saying the jury did not have enough evidence to legally reach the verdict it did. Now, remember, on appeal, this is not about whether the evidence was weak or whether the jury got it wrong. The appellate court would have to agree that no reasonable jury could have reached this verdict based on the evidence presented. That is a very high bar, and the appellate courts typically defer heavily to jury findings. Next, that the verdict was based on passion and prejudice. This argument claims the jury was influenced by emotion rather than evidence. To succeed, the appellate attorney would have to point to something in the record that improperly inflamed the jury, such as evidence or argument that should not have been allowed. Courts do not reverse verdicts simply because a case involves strong feelings. It has to point to an argument or evidence that should not have been there in the first place. Number 3, the court erred by admitting evidence that should have been excluded. This one's a little ballsy. Here the defense is alleging an evidentiary error by the trial judge. Even if an appellate court agrees that certain evidence should not have been admitted, the defense still has to show that the error affected the outcome of the trial. Harmless error does not result in a reversal. Next, that the jury awarded damages in excess of compensatory damages when there was no instruction for punitive damages. This argument suggests that the jury awarded damages that appear to be punishment, punitive, despite not being instructed to do so. If this issue has any traction, it would relate to the amount of damages awarded, not liability itself, meaning that the appellate court, if they agreed, could adjust the damages without disturbing the verdict as a whole. Next, that the plaintiff's case was based on conjecture. Conjecture means speculation or guesswork. Sorry, I'm laughing. The defense is arguing that the jury relied on assumptions rather than evidence. However, circumstantial evidence is legally valid, y'all, and appellate courts do not reweigh evidence. They only look at whether there was sufficient evidence to support the verdict. This one threw me a little bit because I was present for this one. The next is that the court erred by ruling on the Rule 59 motion without hearing. This one stands out again because a hearing did occur. I was there, unless I dreamt that, and oral arguments were heard. This suggests that this language either is boilerplate, meaning this was like a copy-paste template that was just added, or the appellate attorney is trying to get cute because they are attempting to reframe the hearing as inadequate by saying that, hey, this wasn't a sufficient or adequate hearing. And unless the record shows that the judge refused to engage or prevented argument, this issue is unlikely to carry any weight. Lastly, the court erred by denying the Rule 59 motion. This is a general challenge to the trial court's decision and depends entirely on whether any of the other issues succeed. Standing alone, it doesn't create an independent basis for reversal because typically judges don't need to give a reason for denying a Rule 59 motion. They either found that the oral and legal arguments made were sufficient or they weren't. So now we know what they intend to appeal with. I'm actually really glad that the "I didn't have an attorney, so this wasn't fair" argument did not go anywhere. I'm sure everybody involved knows that that would have been dead in the water. And from here, it's a waiting game. We must await the appellate briefing because we need to understand the basis with which they are going to make these legal arguments. It's important to do that before judging on whether these arguments have merit, right? Right. It's important to understand that legal standards matter and that the appellate court does not do do-overs. They are here to look for legal error, so these legal arguments must be solid. Until then, we watch, we read, and we stay grounded. I'll catch you in the next one.